In this video, we'll explain an introduction to arbitration. This video is brought to you by your neighbors LawDocs in furtherance of providing online training and spreading knowledge.
Commercial international arbitration is an alternative dispute resolution, where the disputing parties agree to appoint an impartial arbitrator, based on his expertise and reputation, to decide a commercial dispute, by means of a final and binding award. Arbitration is considered to be international when the parties, facts or the legal matter, extend beyond a single jurisdiction. The distinction between domestic and international arbitration is important as it will affect the enforcement of the award. On the other hand, arbitration differs from other types of dispute resolutions, as the arbitrator is selected by the parties, and unlike mediation and conciliation, the arbitrator not only resolves the dispute, but he also makes a binding decision. Arbitration disputes usually arise from a variety of business deals, such as merger and acquisition, financial services, construction and infrastructure, intellectual property, and purchase and sale agreements. Arbitration is chosen by the parties because it offers the following benefits over local state courts. First, the parties are free to select the place of the arbitration. Second, the arbitrator is neutral, independent, and impartial party, which means an unbiased dispute resolution. Third, the proceedings are conducted in private and confidential manner. Furthermore, the arbitration award is final, with no right of appeal, which saves the parties time and money when compared to court's lengthy appellate proceedings. Finally, the cross-border acceptance of an arbitration award is supported by international treaties. As a result, the arbitration award can be easily enforced abroad, unlike a foreign court judgment.
Now that we've understood the basics of arbitration, let's move on to some important concepts. Firstly, what is a notice of arbitration? Arbitration is said to have commenced when the notice of arbitration requires the other party to take steps in connection with the arbitration or to do something on his part in the matter of arbitration. In the Arbitration and Conciliation Act 1996, under Chapter 5 of Part 1, which deals with the conduct of arbitral proceedings, the provision for commencement of arbitral proceedings state in Section 21 that a notice of arbitration has to be served to the other party, requesting that the dispute be referred to arbitration. The day on which the respondent receives the notice, arbitral proceedings commence under this Act. In a notice of arbitration, a party communicates two things. Firstly, an intention to refer the dispute to arbitration, and secondly, the requirement that the other party should do something on his part in that regard. This will generally suffice to define the commencement of arbitration under the Act. The second important topic is commencement of arbitration. As we already saw, arbitral proceedings commence on the date on which a request for a dispute is referred to arbitration and is received by the respondent. Where a party has obtained interim relief from a court, such a party must commence the arbitration within 90 days from the date of the order granting such relief, or within such further time as the court may determine. Where the seat is outside India, Part 1 of the Act does not apply, and Indian courts do not have jurisdiction over such arbitration. However, unless otherwise agreed, parties would have recourse to Indian courts to seek interim relief and court assistance in taking evidence. There are conflicting High Court decisions over whether two Indian parties can choose a foreign seat. While there is no specific prohibition against such a choice in the Act, unless and until some clarification is brought into the Act or the Supreme Court decides the issue, there is a risk that such an award may be treated as being against public policy. Thirdly, let's look into referral to arbitration. Under Part 1, the courts can refer the party to arbitration if the subject matter of the dispute is governed by the arbitration agreement. Section 8 of the Act provides that if an action is brought before a judicial authority, which is the subject matter of an arbitration agreement, upon an application by a party, the judicial authority is bound to refer the dispute to arbitration. Previously, the Act provided that an application under Section 8 shall be filed not later than when submitting his first statement on the substance of the dispute. The Amendment Act has clarified the timeline to file an application by substituting not later than when with not later than the date of submitting his first statement on the substance of the dispute. The Amendment Act narrows the scope of judicial authority's power to examine the prima facie existence of a valid arbitration agreement, thereby reducing the threshold to refer a matter before the court. In this regard, an arbitration agreement has been considered to be valid if there is merely the incorporation of another document or clause relating to arbitration by reference, or even if there is a general reference to a standard form of contract in one party. In such situations, the intention of the party and the consensus ad idem of the parties is critical, even if the same is apparent from their conduct. In case the judicial authority refuses to refer a matter to arbitration, the parties can file an appeal against such a refusal in the court on which the statute creating the authority confers jurisdiction to hear such appeals. Let's look at some relevant judgments. The first case is the Zhang Bonli Elevator Guide Rail Manufacture Company Limited versus Jade Elevator. According to the facts, Zhejiang and Jade entered into a commission processing contract for the supply of certain products. When disputes arose between the contracting parties, Zhejiang appointed a sole arbitrator and asked Jade to consent to the appointment. Jade refused, and Zhejiang approached the Supreme Court under Section 11(5) of the Arbitration and Conciliation Act. This provision allows parties who have agreed to resolve disputes by arbitration to approach designated courts where the parties cannot agree on arbitrators. The key question before the court was whether there is an arbitration clause for resolution of the dispute between the parties. The Supreme Court opined that invoking party may invoke an arbitration even when the dispute settlement clause in the contract grants an option of getting the dispute adjudicated by the arbitration or by the court. The second case we'll be looking at is Caravel Shipping Services Private Limited versus Premier Seafoods Exim Private Limited. According to the facts, the issue arose in view of an unsigned bill of lading on the basis of which the respondent sought to recover a sum from the appellant in the suit filed by it. However, when the appellant raised the argument about an arbitration clause which was printed in terms annexed to the bill of lading, the respondent alleged that for the purpose of arbitration, the requirement of Arbitration Act is that the arbitration clause should be signed. The court held that it was a matter for arbitration must be that the party either before or at the time of making his first statement on the substance of the dispute and be accompanied by a duly certified or original copy of the arbitration agreement, and such agreement need not be signed for it to be considered valid. The third case we'll be looking at is Parasamica Holding Private Limited and Ambience Private Limited and others. The plaintiffs entered into an apartment buyer's agreement and maintenance agreement with the defendants, which contained arbitration clauses providing for references of all disputes to a sole arbitrator. However, when disputes arose between the parties, the plaintiff filed suits before the Delhi High Court for recovery of money. The defendants, in order for the same, filed an application under Order 7 Rule 11 of the Civil Procedure Code for rejection of the plaint. Subsequently, in 2017, the defendants filed their written statements. The said written statements contained an averment to the effect that a valid and binding arbitration clause existed between the parties. The defendants' applications were dismissed by the court. Thereafter, the defendants filed an application under Section 11 of the Arbitration and Conciliation Act for the disputes to be referred to arbitration. There were two issues before the court. Firstly, when the limitation for filing an application under Section 8 expires the date the written statement is submitted, or on the last day when the written statement can be filed. And secondly, whether the defendant has to specifically pray for reference of the dispute to arbitration in its written statement, or a mere averment as to the existence of an arbitration agreement in the written statement would satisfy the requirements of the Section 8 application. In the present matter, the Supreme Court held that there is no requirement of filing a formal application seeking a specific prayer for reference as long as the party objected to the maintainability of the suit in light of an arbitration clause. The fourth case we'll be looking into is Gawar Paul Ropes versus Coastal Marine Constructions and Engineering Limited. According to the facts, disputes arose out of a subcontract between the appellant and the respondent, following which the appellant terminated the contract. The contract contained an arbitration clause for the resolution of disputes. The respondent invoked the arbitration clause and appointed an arbitrator. However, the appellant disputed such appointment. Thereafter, the respondent filed an application under Section 11 of the Arbitration Act before the Bombay High Court seeking the appointment of an arbitrator. The Bombay High Court allowed their application and appointed an arbitrator to adjudicate the disputes between the parties. The issue before the Supreme Court was that the Supreme Court had to consider the effect of an arbitration clause contained in an agreement which is not stamped. The apex court held that unless the agreement which prescribes the arbitration clause is sufficiently stamped, the court cannot apply an arbitrator. The next case is Chloro Controls India Limited versus Severn Trent Water Publications. According to the facts, the Indian counterpart of these parties filed a suit and sought an injunction against two non-signatories. The Indian counterpart relied on Sukanya Holdings' case to contest that parties ought not to be referred to arbitration since there are non-signatory parties involved in the dispute. The Supreme Court held with the scope and interpretation of Section 45 of the Act that in context discussed that the scope of relevant principles on the basis of which a non-signatory party could also be bound by the arbitration agreement. In the instant matter, the definition of the word party to an arbitration agreement has been expanded under the 2015 Amendment Act to also include persons claiming through or under such party, especially when there is a clear intention of the parties to bind both the signatory as well as the non-signatory parties. The next topic that we'll be moving on to is emergency arbitration. While the Amendment Act has sought to reduce the scope of the court's role in granting interim relief in relation to arbitrations, it has failed to codify a globally recognized concept of emergency arbitration, which under various institutional arbitration rules can be approached for interim relief before the arbitral tribunal is appointed. This omission in recognizing emergency arbitrators and the awards granted by them is conspicuous given that institutional arbitration rules in India provide for emergency arbitrations. For example, the Mumbai Centre for International Arbitration Rules 2016 and the India Council for Arbitration Rules 2005. The Amendment Act now provides a robust process for the constitution of an arbitral tribunal by the courts. The process for appointment of arbitrators, the grounds to challenge an appointment, and the scope of intervention of the courts have been amended to constitute a fair and impartial tribunal. The next topic we'll be looking to in this video, and the last, is statement of claim and defense. The Amendment Act has inserted in it subsection 2A in section 23 of the Act, which allows the respondent in arbitration in support of his case to file a counterclaim or plead a set-off against the claimant's claims which were to be adjudicated upon by the tribunal, provided such counterclaim or set-off was within the scope of the arbitration agreement. This amendment clarifies and codifies the practice already followed internationally to avoid multiplicity of proceedings. Section 23 has been amended to state that the statement of claim and defense must be completed within 6 months from the date the arbitrator or all arbitrations receive notice in writing of their appointment. Thank you for staying tuned. For more information, please contact us at lawdocs.in.